Hi, everyone. Ready? Ready? Okay, now we can start. Welcome back, everyone. Hope you had a nice weekend. I realize I see you on Tuesday, but for me, this is your first time back, so hopefully everyone's doing well. Any questions before we start? Anything from last week on Youngstown or Hamilton or McCullough? Any questions? All right, so first, no class on Thursday. You can come. I won't be here, but there will be no class on Thursday. All right. So we've discussed so far this notion of the separation of powers. And in Youngstown, we say this principle. The principle is this. The only powers that the president can exercise are those he gets from, number one, the Constitution, or number two, from Congress, from a statute, right? The president does not have any powers that are not from the Constitution or from the Congress. The focus of our class for the next couple days is what sorts of powers can Congress give to the president? The answer is not whatever they want. That is not the right answer. Article 1 of the Constitution limits the sorts of powers that Congress has and limits the sorts of powers Congress can give or delegate to the president, right? A delegation, you may have heard that word or not, delegate or delegation means to give, right? When Congress gives powers to the president. So a really easy example of this, and where did I finish last time? Anyone remember? Okay, I appreciate your honesty. Is that Alexa? No. Morgan? Morgan, thank you. So Morgan, we said in Article 1, Section 8, right? This is a list of all of Congress's powers. Congress has the power to create a postal system, right? Congress has the power to create a postal system. Who actually runs the postal system? Is it Congress? Who runs it? Which branch of government? Which branch of government is that? I'm sorry, I can't, you're picking way too low. Which branch of government actually runs the postal system? You gotta speak louder. Executive, thank you. The executive branch. So Congress passes a law that says the Postal Service Act of 1789, I have no idea that's a law, but let's pretend it is, right? And then the executive says, okay, I'm going to enforce that law. So we have a postmaster general, right? You never think about this, but the postmaster general is an executive branch official. And the president nominates, Joe to be the postmaster general. The Senate confirms him. And now the postmaster general has the authority to run a mail system based on the statute Congress enacted. Easy, right? Simple example. Congress says, we give you, postmaster general, the power to create a postal system. We give you the power to hire postal carriers. We give you the power to purchase horses. We give you the power to purchase a wagon, whatever it is necessary to run a postal system, right? Everyone with me so far? There's nothing problematic about Congress enacting a law that delegates power to the executive branch. In every respect, this is an executive power. You can execute the statute. You can carry out the statute. You can hire mailmen, right? You can hire horses. Christine, let me ask you a follow-up question, though. What happens if instead of giving why is everyone so late? What's going on today?
Oil and gas.
What oil and gas?
The commissioner was here.
Well, the class is at 2:20, so 2:20, so get her in time. All right? What happens, right? If, I'm sorry, who's on to? Christine. What happens if instead of Congress telling the postmaster, you can spend this much money on horses and this much money on postal roads, whatever else, right? Congress said, postmaster, we give you the power to write your own laws. We give you the power to decide what kind of mail you can carry. We give you the power to decide how to structure your post office. We give you the power to decide whatever you want do whatever you want. Here's a blank check for $1 million a year. Have at it. Do it. You see a problem there? How so? Good. Okay, I like where you're going. Delarm? Delarm, let's go to Article 1, Section 1, very first page of the Constitution, right? Which branch, and it's up here if you don't have your Constitution, but you should. Which branch, Delarm, of the government has the legislative power? It's not a trick question. Yeah, exactly, right? You're going to get another question. You're not the hook yet, right? The legislative powers are vested in a Congress of the United States. So, Delarm, the follow-up question is that, can Congress give away its legislative powers? Can Congress give to the executive branch the power to make laws? Yeah, the legislative power. Can Congress give to the executive branch the power to enact laws?
I guess no.
Okay. So the simple answer, we'll get a little more complicated in a minute, right? But the simple answer is that Congress cannot give away its legislative powers. This was a theme in both cases, but I want to do it up front because the book does not do a good job explaining this. Congress cannot give up its legislative powers. This is something that's been called the non-delegation doctrine. Non-delegation doctrine. This is the doctrine that Congress cannot give up its legislative powers. Why? Right here. It said all legislative powers here and granted go to Congress. It doesn't say Congress has some legislative powers, the executive branch has others, but all legislative powers go to Congress. Right? This is going to seem really obvious now, but by the end of the class, it's going to seem a little more confusing. We'll start simply enough. So it seems that the only thing that Congress can give to the president are powers which he can execute, right? Congress can give the president powers to execute. Congress cannot give the president powers over legislation. Everyone with me? Any questions on that? It gets complicated later, but just stop me if you don't get that much. Okay. So we have this thing called the non-delegation doctrine. Congress can't give legislative powers to the president. Therefore, all lawmaking must happen within Congress. All lawmaking must happen within Congress. And the Congress provides a blueprint, a step-by-step guide in order to execute the legislative powers. Congress gives a step-by-step guide in order to make laws. Now, how many of you have seen the classic Schoolhouse Rocks video, How a Bill Becomes a Law? Right? Remember that. Hopefully you recall it. But if you don't have time to watch the video, all you need to do is read Article 1, Section 7, Clause 2. Turn to your constitutions. When I say section, you should be flipping. It's not. It'll become habit. Don't worry. Article 1, Section 7, Clause 2 spells out the process by which a bill becomes a law. It's only one sentence long. All right. Is that Sydney? Sydney, please read it, please. The clause. Okay, thank you. What does that mean? Explain the process of how Congress takes something called a bill, which is like a proposal, and makes into a law. What happens? Okay, so the House of Representatives passes the bill. Okay, what happens next? Same bill has to pass the same bill. Okay, then what happens? Okay, very good. I'm going to stop you right there. This process is known as bicameralism and presentment. Spelled that wrong. Bicameralism and presentment. Bi meaning two, presentment. I'm sorry, Kama, house, right? Mono, one, rail, right? Bicameralism and presentment means both houses pass the bill and it's then presented or delivered to the president. This is a prerequisite for Congress to do anything. Everything it must do to pass a law goes through both houses. You can't go through just one. Okay? Questions on that? Now, I'm going to pause here briefly. There are some things that a house can do by itself. This is mentioned later in the reading. Anyone want to guess what a few things one house can do by itself are? Yeah?
Senate can ratify treaties.
Senate ratifies treaties, only Senate. What else? The House representatives vote to impeach. The Senate holds a trial. Anything else? There's one more. What can the Senate do by itself? Exactly. Approve presidential appointments. The Senate alone has the power to confirm presidential appointments. So there are specific instances in the Constitution where a House can act alone. But in all other instances, the House cannot act alone. Both houses, bicameralism must happen. So what happens after presentment? Okay, so Michelle, can you read clause 3, please? Or at least start reading it. I'm going to stop you in the middle, but start reading at least. Okay, stop right there. What does that mean? I told you I'd stop you. Michelle, what does that mean, every order, resolution, or vote? What does that mean? Yes. So here was the fear. And this was actually James Madison's fear, right? So clause 2 says every bill must be approved by both houses and then signed by the president. What if we don't call it a bill, right? What if we call it, I don't know, a resolution or a vote? What if we just call it something else? Madison was afraid that future Congresses could sidestep the Constitution by calling it something else. So they basically said, no. Every order, every resolution, or any vote, right? Anything you vote on must have the majority of both houses of Congress. Everything. And everyone understand? You can have a resolution, a joint resolution of Congress. We have those. It's just another name for a bill. It doesn't actually avoid the requirements of Article 1, Section 7. All right. So Randall, sorry, I interrupted her 5 seconds in. Read the entire thing from the beginning in clause 3.
Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except in question of amendment, shall be presented to the President of the United States.
Okay, stop right there. So basically, everything they vote on has to be transmitted to the President. Both houses can act alone. All right, keep going, Randall, please.
And before the same shall take effect, shall be approved by him or be disapproved by him.
Okay, stop right there. Okay. The president has responsibility for signing laws. Congress cannot make laws by itself in the initial instance. The president has the option to sign it. Randall, what can the president do if he decides not to sign it? Keep reading. Shall be approved by him. Yeah, keep reading.
Shall be repassed by 2/3.
No, you skip.
Shall be approved by him
Or
be disapproved by him.
Good, stop right there. This is what's called the veto. I realize this is probably, civics education, but I assume you know nothing, right? The president has the option after a bill has been enacted to veto it for whatever reason he wants. He does not need a reason. He can just not like it. He doesn't want to spend the money, this or that. The president always retains the power to veto a bill. Always. Okay? But the genius of our system, right? Unlike the king of England could veto any act of parliament. The genius of our system was that the elected branches could override the veto. Felipe, please read the last part of the clause. Or being disapproved by him.
Shall be repassed by 2/3 of the Senate and the House of Representatives according to the rules of interpretation prescribed in the case of.
So Felipe, tell me, what happens if the president vetoes a bill? What can Congress do?
They can override it
How?
by voting 2/3.
Exactly. So think about it. A majority of both houses is necessary in order to turn a bill and put it before the president. The president can sign it. If he chooses not to sign it, he vetoes it. Even if the president of the United States vetoes a law, if 2/3, a supermajority of both houses of Congress agree, the bill becomes law just the same. This was a remarkable innovation, unknown in the history of the world, that the executive, the monarch, or whoever it is, can be overrode by the legislature. This was a very novel innovation. Okay? So in this sense that it's really hard for something to become a law. Both houses have to agree, and the president agrees. And even if the president doesn't agree, they need 2/3, a supermajority, which is a very big swath of the American people who have to concur. It's very rare for a veto to be overrode. It doesn't happen very often. In today's society, I can't remember the last time it happened, but it's fairly rare. Okay, so any questions about how the bill becomes a law? You can go watch School After Rocks later. Any questions about that? All right, so the next topic, as we move towards INS v. Chadha, is something that's very relevant and will be a live issue this year, is about the scope of discretion the legislative branch gives to the executive. And in the context of immigration, we'll be talking about this, I think, in a week or two. It's very, very, very live, as we say, as we speak. So, is it Angela? Angela, let me ask you something, right? So when Congress wants to enact an immigration system, right? Congress has the power for naturalization. That's not a question, right? Is Congress going to pass a statute that says, Mr. President, we want you to admit these people, don't admit those people, and put these people on a waiting list? Is Congress going to enact that kind of statute? No, they didn't, actually. It's hypothetical, right? Do you think Congress, in a nation of 300 million people, is going to enact a statute specifically saying, we want you to admit these people, but not those, these are not those? Do you think Congress is going to do that? How do you think if Congress wants the president to manage this huge immigration system for 300 million Americans, right? How do you think they're going to do it? What do you think they're going to do? So let me ask you this question, all right? Who do you think, on a day-to-day basis, is better suited to decide who to admit and who not to admit, who to remove, who not to remove? Congress or the president? Congress. So every single time their immigration decision has to be made, Congress has to pass a bill? So who do you think is more better suited on a day-to-day basis?
Oh, sorry, the president, once the legislative branch passes the bill, then the president or the executive branch is able to operate in a way to enforce those types of
Yes. Yes. So the way our modern society has been structured, for better or worse, right, is that Congress gives the executive what's called discretion. Okay? Congress says to the executive branch, listen, we'll give you $500 million a year for deportations. And we'll give you some guidelines about who can be deported, what circumstances we deported. But for the most part, we're not going to tell you on a day-to-day basis how to do your job. Why? Let's see, Daniel, what is the only way that Congress can speak to the president? The only way they can speak to the president. They have one way.
Speak to the president?
Yeah, it's only one way they can speak to him. We just did it. It's on the screen. What's the only way Congress can tell the president what to do?
Are you talking like through a veto, the 2/3 vote?
Before the veto. What's the only way Congress can tell the president what to do? It's really easy. You're overthinking it.
Pass
a bill!
Okay.
Yes. Congress can't send press releases or tweets or blog posts to the president. Here's what we want you to do. I'll get you in a second. The only way that Congress can communicate to the president is by passing a bill and say, veto it or sign it. And if you veto it, we'll override it. Is that Ryan? Oh, I'm sorry, one row. Zach, yeah, sorry.
So my question is whenever Congress provides discretion through the funds, when they say it's like for like a particular subject, like this fund is particularly for immigration, and then he would decide the specifics of it, like how, like I guess I'm not clear on is with like how far his decision making would be able to extend.
So in about 2 weeks, we'll discuss the United States versus Texas case, immigration case. I'll answer the question in much more depth then. But the short answer now is that to varying degrees, Congress cares or doesn't care how its money is spent. In the Clinton case, so some say, well, you can spend, as much as $1 million or none at all. We don't really care. In other cases, they say, we want you to spend this exact money in this bridge project in this county because my people want this bridge to be built. So in different situations, the president's given a different amount of leeway.
Okay, so but it would still have to be like towards a particular thing. Like they said, like we're giving you money, you can decide what specifically to do with this, but it would need to be towards immigration. Or
you think, but there are lots of slush funds that are created that, especially in defense, where you don't know where the heck the money's being spent. Yeah. If you find a detailed budget for the CIA, good luck with that. Yeah. Defense. Yeah. That's hold on, Tariq.
I don't know if you're going to get to that, but I don't understand why Congress is concerned about a certain
Concerned about what? I didn't hear what you said.
I don't understand why Congress is concerned about a certain state of.
I'm going to get there in a minute. I promise I'll get there in a minute, okay? So generally speaking, right, Congress is not able on a day-to-day basis to deal with the case-by-case situation because the only way Congress can act is by majority in both houses and signing a bill. That is not a very effective method. So in the 20th century, Congress has told the president, okay, you know what? We're not going to supervise you on a very close basis. We're going to give you a vast amount of discretion, and you can then hire the Immigration Customs Enforcement, or INS, as it was called at the time, to manage this. You can hire all these people. You can pass these regulations, and then you can decide who to stay or who leaves. Okay? However, with the immigration law in question, Congress said, we're going to give you all this discretion, but we want to keep a check on it. We want to say, if you decide not to deport someone who otherwise would be subject to removal, if we decide not to remove someone who otherwise is subject to removal, we want to say over it. If a majority of one house of Congress votes, we are effectively withdrawing your authority to not deport that person. In other words, we'll make this specific. This is Mr. Chadha. Okay? This is Mr. Chadha. He came to the United States in 1972 on a student visa. His visa expired. He was ordered to be deported to his homeland, but due to the vagaries, he was from Kenya. At the time he was born, Kenya was a British colony. Since he left, Kenya gained independence. And surprise, surprise, Kenya didn't want him because they didn't want any British subjects. So he was basically a man without a country. It was the terminal of this movie with Tom Hanks. Not quite that, but it's the premise of the Tom Hanks movie was some guy, Tom Hanks, took off in an airplane, and while he was in the air, his country had a coup, and there was a violent overthrow of the government. So by the time he landed, his country no longer existed. And his passport, had no country. So he's basically stuck in the airport terminal for 2 years because he had nowhere to go. He couldn't enter the United States because he had no, entry visit here, and he had no home country. He couldn't be sent home. So he lived in the terminal, and he lived off ketchup packets at Burger King and other product placements. But the premise is Chadha had nowhere to go. So even though he was subject to deportation to a country that didn't want him, they said you got to go. So the Attorney General was authorized under the statute to not deport a certain number of people. Congress gave this discretion to the Attorney General not to deport a certain number of people. He gave him this discretion. Okay, everyone with me? However, Congress said, we don't want to give this discretion 100%. We want to keep a fairly easy method of dialing that back. We want to keep a fairly easy method of overturning it. So this led to the legislative veto. Either house, by a simple majority, could block the action of the Attorney General not to deport this individual. Okay? Everyone understand the facts here, right? One house of Congress could overturn the Attorney General's decision not to remove Mr. Chadha. Yeah, actually, he became I don't call a minor celebrity, became a little bit of a celebrity in the 80s when this case happened. There was a book about him. There were all these TV shows about him. But you know, it was a mini sensation at the time. So before we get to the bicameralism presentment, I want to discuss one aspect of Justice White's dissent. Justice Byron White was a John Kennedy appointment. Although he was a Democrat, he was fairly moderate. And he's most famous for being a professional football player. He played college football at Michigan, and it was in the NFL for a couple of years. He was called Whizzer White. The Supreme Court has a basketball court on the top floor. It's often called the highest court in the nation. And for years, the justice would actually play basketball. And apparently, he was really good. He was a very good athlete. He was also very interesting justice for his views. He was the only liberal who dissented in Roe v. Wade, among others. But he had very idiosyncratic views. And one of the points Justice White made, this wasn't his ruling, but one of the points he made was, why did Congress decide to enact this one-house veto? Cody, according to Justice White, why did Congress want to keep this one-house veto in the first place? And think about the non-delegation doctrine. You're on the right track, but give me more. What kind of authority had Congress given in the first place to the Attorney General here?
The authority to pick and choose.
Yes. Think about this for a moment, right? Congress effectively gave the Attorney General the authority to ignore the law. The law says Chadha has to be deported, right? He extended his visa. There was no legal dispute. He was not here legally, right? There's no legal dispute. But Cody's right. The statute gave the Attorney General the authority to basically disregard the law. They said you can exempt a certain number of people every year and not remove them. Charles, can Congress give the president the power to suspend laws?
No, they're not allowed to give away legislation.
Bingo. 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 First point of the day, right? Very first thing I said. Congress has legislative powers. The power to make laws and the power to repeal laws is vested in Congress only. What Justice White basically suggests, and he doesn't hold this, to be careful, this is not his holding, but what he suggests is Congress recognized it was basically giving away legislative powers. Congress recognized it was basically giving the Attorney General the power to repeal the law as applied to Mr. Chadha. So the law says if you're here legally, you have to be removed, but the law gave the AG the power to suspend that provision for Mr. Chadha for no other reason that he didn't want to deport the guy. There was no legal basis to keep him here. So in another time, and we'll discuss this later, but in another time in American history, the Supreme Court very well may have struck down this law as being unconstitutional. The court may have actually said that this violates the non-delegation doctrine, that Congress cannot give the president the power to repeal laws, that Congress cannot give the president the power to ignore laws at his discretion. Another time, the court has moved away from that. In 1936, it was a big pivot point in American history we'll spend a lot of time on. During the time of Franklin Roosevelt, the court basically ignored the non-delegation doctrine. The court said we're not going to follow it anymore. And the decision of the court to ignore it gave rise to the modern legislative state. I'm saying the modern administrative state, right? Today, the non-delegation doctrine is on life support. It doesn't really have much weight, although some people think it ought to. But it's a fairly moribund, if I may use Justice Kennedy's phrase, fairly moribund doctrine. It's dead. But what White says was, look, they realized how much power they were giving to the Attorney General, so they wanted to keep a little bit for themselves. And you know what? Two wrongs make a right, right? We're going to give you some unconstitutional power, and you give us some unconstitutional power back, right? Congress will give them this unconstitutional power over suspending laws, and the president gives them the unconstitutional power to veto something after the fact. So what Justice White says, and again, whether you agree with him or not doesn't matter, but his point is that we've already gone past this formalistic notion of separation of powers. Congress is already giving away its legislative powers, so why not give Congress a veto? Right? Congress already gave up the prerogative of keeping its powers, so why can't the president give it some veto power? So what Congress was trying to do was to maintain some sense of power over this unbridled delegation. Everyone get that? It's a very sophisticated concept, but it's a nuance in this case that almost everyone misses. Everyone, questions? Okay, so that's Daniela. So Daniela, let me ask you another question. Do you think Congress would have enacted this statute and given the Attorney General all this power if they didn't have this one-house veto?
Probably not.
Why not?
Because there's no way of checking them.
Exactly. This was a point of Justice Rehnquist's dissent. He wasn't Chief Justice yet. Berger was still in power. Justice Rehnquist's dissent was that Congress would have never passed this statute without the one-house veto. This one-house veto had been used in 300 other bills, right? It was a fairly common legislative innovation. The reason why Congress was comfortable in giving this broad discretion to the president was because they knew they could ratchet it back in case they abused it. Congress gave this president because they knew they could check it through this one-house veto. And it's not that hard to pass a bill in one house. In this case, they voted on Mr. Chadha without even thinking about it, right? It wasn't even a debate. It was a voice vote. So before we even get to the bicameralism presentment, the first issue, right, is can Congress even give this broad legislative power? Does it violate the non-delegation doctrine? Second, would Congress have even enacted this? This is the question of severability, right?
Didn't Congress in the first place enact this act that they already figured out, and then now they say it's unconstitutional?
Well, only part of it. And this is the part of the decision which you probably glossed over, but it's very important. Something called severability, right? So what happens if you have a big statute? Parts of it are valid, parts of it are unconstitutional. Who am I up to? Amber? Amber, what happens if you have a big statute, right? This is a 1,000-page statute, I'm sure. You have all this stuff that's perfectly fine. You have one provision that's unconstitutional. What should the court do?
If you're accepting one part and accepting all of it, you can't just.
Can you chop off, like, if you have a foot that gets gangrene, right? Right? Can you just chop off the gangrene foot? What does the court do here, though?
They try to just take what they like of it. And
Yeah.
ignore the part.
So here the court just amputates the foot and they let the rest of the body exist. What's problematic here, and this is the point Justice Rehnquist raises in dissent, is that Congress would have never enacted this law without the one-house veto. Right? This bill doesn't work without the veto. So what basically the court did was they took away this one-house veto and gave the president all this power, which you have never had in the first place. What's interesting about this case, Caleb, so this was actually during the Reagan administration. What do you think President Reagan thought about this one-house veto? Do you think he liked it?
Probably not.
Why not?
Basically took away the power that they had to give.
Yes. This took away the president's power. The one-house veto could basically check the president's power. Now, what do you think Congress thought about this provision? Do you think they liked it?
Oh, for sure.
So what actually happened here is fairly rare. President Reagan's Justice Department said, we will not defend this law. President Reagan's Justice Department said this law is unconstitutional. So what actually happened was the House and the Senate argued in court to defend this bill. Can you imagine? Right? In the Supreme Court, I think there were 4 or 5 lawyers. I've lost count, right? You have the lawyer for Chadha. You have the president up there saying, yep, this law is unconstitutional. And you have the House and the Senate saying, no, this is valid. This is a very complicated case, probably one of the most important cases of the 80s. in terms of the separation of powers. So it's unsurprising the president doesn't like this because it limits his power. The president does. So at the end of the day, what happens? The line item veto, the one house veto goes away. The president has all this power over authority, and Congress cannot check it. Okay. There's one other. Is that Caleb? No. You're sorry. Dylan? No. Colby.
Yes.
Colby. Thank you. Colby, there's one other aspect of the case that was alluded to in Justice Powell's dissent. I promise we'll get to the actual case in a minute, but I want to get rid of these preliminary issues first. What did Justice Powell say in his dissent, Colby? It was very short. The book gave you like a 3-sentence, thing. By the way, always read the concurring opinions and the dissents. Common law is specific in that very often the dissents and concurring opinions are actually better, and they're often right. Don't think just because it's a majority opinion, it's correct. I don't care who writes it. So the concurring opinion was by Justice Lewis Powell. Justice Powell was a Virginia moderate who was always a sort of middle of the road vote on the Supreme Court, and he always tried to approach things in a more narrow fashion. So Colby, what did Justice Lewis Powell say in his concurring opinion?
Well, I mean, he said that Congress views it as essential. The actual bill is essential to control.
And what else did he say? The very end.
Yeah, it has assumed judicial.
Judicial.
Yeah.
Whoa. So we say in the first day of class, right? The legislative branch has legislative powers. The executive branch has executive powers. And the judicial branch has judicial powers. Duh, right? Elizabeth, how is the Congress here exercising judicial powers? And this relates to a topic we have later in the class. What is Congress actually doing here?
Deciding whether or not
Who's they?
deciding whether Congress can do
When Congress issued its one-house veto, what did it actually say about Mr. Chadha? Not that he can say, the opposite. He's got to go. Congress passed a bill. I'm sorry. Congress passed this one-house statement that said, Chadha's got to go. Elizabeth, what do we call it when Congress passes something that singles out one person for a punishment? What's that called? It's in the reading for later. What? What's it called in the Constitution? Do you know? It's in the reading. Nicole? A bill of attainder. What's a bill of attainder?
that you can't single out a single person for like punishment for a crime,
Yeah.
like without a trial, fair trial.
So you see what Powell's getting at here, right? Article 1, Section 9. Turn to your Constitution, right? Article 1, Section 9. No bill of attainder or ex post facto law shall be passed. Congress cannot pass a bill, whatever they want to call it, that inflicts punishment on one person and one person alone. They can't do it. It's forbidden. This is why Justice Powell says this was a judicial function. The branch of government that's meant to punish people in this fashion are the courts and not the legislative branch. If you read Powell's lengthier dissent, there's a lot more discussion on this. They gave you only like 4 sentences, which is frustrating. But Powell says, look, this is a bill of attainder. They're singling out one person for punishment. As we'll get to later, the bill of attainder clause is basically dead also. You'll notice in this class, the Supreme Court's killed a lot of provisions of the Constitution. We have this document we keep in our pockets and we wave it around, right? But over the last 200 years, the Court has basically cut out chunks here and there. One of my friends and mentors, a guy named Randy Barnett, has a book called Restoring the Lost Constitution, and the cover is a picture of the parchment of the Constitution with various pieces carved out. And this part's missing, and this part's missing, and this part's missing. I'll get you the cover. But the actual bill of attainder clause is still in the Constitution, but the Court has more or less, disregarded it. Yeah, this is the cover. It's a book which, if you're interested in constitutional law, I'd recommend you read at some point. Okay. So there's also the bill of attainder question. So there's significant unconstitutional stuff going on here. There's lots, right? There's non-delegation doctrine problem, right? There's bill of attainder problems. There's also the issue of severability, where you can't really separate the one-house veto from the rest of the bill. So there's lots of errors in this case. The majority, though, probably still gets it right under current law, but we'll discuss why. So let's go over here. Travis, so the majority opinion was by Chief Justice Warren Burger. I have it up here. He was a Nixon appointee, a law and order conservative who turned out to be somewhat liberal, somewhat conservative, somewhere in the middle. Not a very good Chief Justice. He's often regarded as one of the not best Chief Justices we've had in recent time. He created lots of friction on the court. People didn't like him very much. It was not a good time. Although one of his law clerks was a guy named John Roberts, who we will come back to soon enough. Young pup named John. So, to the majority, Travis, what was constitutionally problematic about the one-house veto?
It was the bicameralism requirement to present laws in both.
Good. Okay. The majority opinion is like Justice Black in Youngstown. The majority opinion is like Justice Black in Youngstown. It's a very formalistic approach to the Constitution, right? What do I mean by that, Dan? What do I mean it's very formalistic? How is the majority opinion in Chadha similar to Justice Black in Youngstown last week?
Well, it tends to follow directly the text of the Constitution.
Exactly. Perfect answer. You recall Justice Black said, look, we have Article 1, legislative powers. We have Article 2, executive powers. Shutting down a steel mill and seizing it, that's a legislative power. It belongs to Congress and not the president. Therefore, the president loses. Very easy, right? Very straightforward, very formalistic. What do I mean by formalistic? It follows a process. You have the text of the Constitution. That's what you follow. Taylor, what was the text-based argument in this question? What text guided Chief Justice Burger's decision?
Section 1, or I'm sorry, Article 1, Constitution.
Section?
I guess Section 1.
Okay, but more specifically?
Section 7.
7, bingo. What does Article 1, Section 7 do? We've discussed this before. What? Tell me.
It sets up the bicameralism.
It sets up the process. Burger says Article 1, Section 7 spells out in detail the process by which a bill becomes a law. Passes one house, passes the second house, presented to the president, and signed. Burger says anything short of that, cannot have the force of law. Anything short of bicameralism presentment cannot have the force of law. Everyone get that? Everyone understand that? Unless it passes both houses and signed by the president, no force of law. Is that Laura? Laura? Laura, thank you. Laura, in this case, did the one-house veto satisfy the strictures of Article 1, Section 7? No, why not? The answer is easy.
Because it didn't help pass both houses.
Yeah. He said, look, it says here, every order, resolution, or vote requires concurrence of two houses. It's right there. James Madison wrote it. We do not have that here. We do not have that here. Therefore, this one-house veto has no effect. Okay? Now, we'll go over here. Zachary, there you are. Zachary, does the Chief Justice address whether the statute violates the separation of powers?
Yes.
Well, what does he say? He doesn't.
Yeah.
Does he address the non-delegation doctrine?
No.
That's right, he doesn't. And the reason why is a common principle of constitutional law. The court never steps further than they need to. The court usually strikes stuff down and makes constitutional law as narrowly as necessary. They're not going to make broad statements of law if they don't have to. But for the minimum, he takes this formalistic approach and says, listen, you guys, you can't cheat. You can't shortcut around this bicameralism presentment requirement. This is this zone. So everyone get this. I understand the majority. It's really easy. The majority opinion is so simple to understand, but there's a lot of moving parts which I covered first. Yes, sir.
Question. So from what I understood, Congress's one-house veto was taken away. The president retained the power.
Yes. Isn't that something, right?
Was there anything later on done to somehow curb that power, or does the president still retain it today?
Oh, I know the answer to this one too. I've had to learn more about immigration law in the last year than I ever thought I would have to. So the short answer is yes. I may be getting this slightly wrong, but I'm in the ballpark. After this decision, Congress passed a subsequent statute that limited the number of people who the president can decide not to remove each year. I can't remember what the number is. I'll say it says 5,000. I'll make up a number, right? So instead of giving Congress the power to veto this person, that person, Congress said to the president, okay, you know what? There are 5,000 people each year that you can decide not to remove. That's your limit. So in that sense, Congress was actually able to somewhat get around this decision. It's not they can't pick particular people, but now the president has a budget how many people can decide not to remove.
So we put a number on the discretion.
Yeah, I don't know the number. I'm making it 5,000. I may be totally wrong, but I know there's numbers in the thousands. So the short answer is that this also didn't end the world, right? Congress figured out a way to get around this. So usually, despite people think, oh, this is the worst thing in the world, they usually figure a way around it. It's not that difficult. But it was convenient, right? Right? Instead of telling the president you only limit to 5,000, they say, well, for reasons I've tried to find out, I don't know. Some member of Congress said, this guy's a jerk, send him home, right? I don't know why they singled out Mr. Chadha. I have no idea what the heck his deal was, but they singled this guy out. So what the court said was, even though this is convenient, that's not a compelling value. So I want you to turn to the very last page of the Chief Justice's dissent, because this is a point that, if it was a page number, just call it out. The very last page of the Chief Justice's dissent, before 269, right before Justice Powell comes up. Was it 268? Okay, 266. Thank you. Chief Justice Berger writes that this is definitely appealing, right? It's always easier to have one house than two. But is that Helen? Yeah. Helen, what did the framers of our Constitution, according to the Chief Justice, think about efficiency? Is our Constitution meant to be an efficient document? What does Berger say? I'm asking you today. What does Berger say?
What does Berger say?
Yeah.
About the...
Was our Constitution designed to be an efficient document to make things easier for Congress?
No, I don't. I think they... No, I think efficiency...
I'm asking, what did Berger say? I'm asking for your opinion. I want to get through a Berger. What did he say?
I think...
Can you read? Yeah.
I'm sorry?
Read. What did Berger say about this?
I mean, from what I got from it, it seemed like there are other things that were more important than efficiency.
What was more important than efficiency?
I'm not sure.
Okay, is that Clayton?
Yes. It says they wanted it to be exhaustively considered procedure.
Exhaustively considered procedure. That's the money quote, right? Exhaustively considered procedure. Our government was not structured to be convenient. Our government was not structured to make it easy to pass laws. Indeed, we came from a government where it was very easy to pass laws, right? Kason, what did Berger say about the government that preceded us, that the problems with that government were so easy to pass laws?
That it's going to sort of...
Which government am I talking about? England. Who was in charge? The king. Had the king make laws? Whatever he wanted. Right. The court says this is an arbitrary government. This is an arbitrary government where, hell, in parliamentary countries, it's very easy to pass laws. Very easy to pass laws. And if the prime minister becomes unpopular, you hold a referendum, throw him out of office. We don't have a democracy. We don't have a parliamentary system. We have a republic. Was it exhaustive? What was that phrase again?
Exhaustively considered.
Thank you.
procedure.
exhaustively considered procedure. You have to go through all of these checks. You have to jump through all of these hoops just to make it to the point where the president can sign it or not. Efficiency was not a value that our framers ranked highly. And then we have a citation to Youngstown, right? Emma, what's the citation to Youngstown? What does the court say? At the very end, it's the last sentence of his opinion.
He says, with all the obvious flaws of delay and untidiness and everything, there's no better way to preserve freedom.
Yeah, what does that mean?
Essentially, even though it's not a perfect system, the flaws of having it take longer are essentially not really flaws because they'll have better quality.
Yes, and this was Justice Jackson's final paragraph in this concurring opinion. We'll come back to this, right? Remember he said, the courts will be the last and not the first to give this up. Jackson looked across at Nazi Germany, an efficient country as anything, right? Trains ran on time. Actually, they didn't. This is actually a myth. Fascist trains were not on time. People say that they were not very on time. Fascism is very bad at making things run. But anyway. But he says, look, you have these efficient countries where laws can pass, Hitler can rule by decree. That is not the system we have. You can't avoid the Constitution to get around these delays which are baked into our system. Okay. So for whenever someone says that, our Congress is gridlocked, they're not passing laws, they're awful, well, when people don't agree, the status quo is you don't pass laws. Laws require massive consensus from large amounts of people to be enacted. So when laws aren't being passed, that's a reflection that people don't agree on what to do. Not that the system is broken. In fact, I humbly submit that when laws aren't being passed, it shows the system is working, because we're not supposed to have laws being passed unless they're supported by a majority. Okay, so that is the system we live in. Berger says efficiency is not a sufficient virtue to do it. To Berger, I say, well done. Oh, come on, there it is. Okay, awful, awful, burned, right? So. Any questions on the majority opinion, Berger? Any questions on Berger? Everyone see that? All right. We already discussed Justice Powell's, but to reiterate, he effectively says this is something that we should be very hesitant to do. This is a process that Congress has implemented in hundreds of statutes. Who are we to invalidate all these statutes all at once? Now, they didn't actually invalidate all the statutes at once, but after this, a Congress can never exercise the legislative veto. If they tried to, it'll be challenged in court, and you cite Chadha. So this basically, in one fell swoop, took out 200 laws. And took all these statutes that Congress would have never enacted and enacted it without this provision. And again, at the end, he says, this is a judicial process. He concurred in the judgment, said, listen, I'm just going to strike this one down because it's bad, but I'm going to leave all the other ones alive. Whatever. Okay, so everyone with me on Powell. Is that Kiara? Kiara, what did Justice White say? We're talking about White, but how would you characterize his sentiment or what he thought about this topic?
He said it sounded like a death knell for the.
Yeah. Right, and what did Justice White think about this act of Congress to invalidate all of these legislative vetoes?
He liked it at all. He said, without the legislative veto, they would face the House's choice to delegate.
Yeah,
Or
exactly. So she's exactly right, and this is the point we opened the class up with, right? Congress basically made the decision, decades ago that look, we're lazy. We're not going to be in the business of supervising and micromanaging every aspect of what the president does. So we're going to give these broad delegations of power to the president, but we want to keep this insy-binsy, teeny-tiny check on it that if the president does something bad, we can pull it back in. This was a convenience, right? And for a long time, the president was fine with this, right? The president said, fine, we'll share this power, right? I'll tell you what, Congress gives the president legislative power. The president gives Congress a veto power. They swap, like, you eat a lunch when you're kids, you swap lunches, right? White says this is a good thing, that the branches of government should be able to rearrange their own power. They should be able to restructure their own power. Davian, why does Justice White think that the branch of government should be able to shift how their own powers are structured? Why is that something that the Congress should have?
I mean, you feel like they should, by the time it goes through all of that, they should be able to make decisions that are for the people.
Yeah. Yeah, exactly. In other words, if this is helping people, right, and it's not bothering, well, maybe it bothers Mr. Chadha, right? But for the most part, people are okay with this. Why should we as unelected judges be interjecting ourselves, right? The Constitution isn't actually that clear, right? Does it say in the Constitution that, you know, the president can't, that Congress can't do this? Well, maybe yes, maybe not. Close call, I don't know. So White says, let's be more deferential. White's opinion, actually, no. So we said that Justice Black in Youngstown is like the majority. Justice White, I think, is closer to Justice Jackson, right? You have black and white, right? White says, let's not be so strict. Let's not read the text of the Constitution so closely. Let's look at practice. Let's look at Congress has done. They've been doing this for, 80 years with all these different things. Let's be flexible. Let's have a pragmatic approach. Let's not pretend that we can second guess what's best for them. Okay? He admits, citing Justice Jackson, that administrative agencies are a, quote, deranged or three-branch government theory, right? This fourth branch of government has deranged our three-branch of theory. As a historical matter, he's exactly right. The administrative state is very hard to reconcile with the original understanding of the Constitution. That's not to say it's wrong. I'm not making that point. But it's very difficult to reconcile the administrative state with the original understanding of our Constitution. It is. But the court has blessed it. The court has blessed this fourth branch of government. So as a consequence of blessing the fourth branch of government, why can't they also bless this attempt for Congress to retain some control? In other words, if they approve this massive regulatory leviathan, why can't they give Congress an itty-bitty way to check that leviathan? That's Justice White's point. He says this is not tyranny, but a necessary check on expanding the power of agencies. White says this is how we limit government, right? Don't give so much discretion. All right. Any questions on Justice White's dissent? Yes, Dan?
I thought he was making an argument as well that because of the size of government and the increased responsibility of government, we should lean more towards efficiencies rather than the formalistic.
Yes, that's exactly right. He says we should have efficiency as a model of government. In fact, Justice Breyer's dissent in the Clinton case, we'll do in a few minutes, makes very similar points, that we should let the government experiment, see what works best for them, and not second guess them. Is that correct? Any other points on Justice White? Oh, yes, sir. It's Taylor.
Yeah. In Justice White's opinion, he said that without the legislative veto, Congress would be left with a Hobson's choice of basically either having to write a law that was so specific that it would cover every single possibility, or in the alternative, to just let the executive branch do whatever they wanted as far as that power goes and still do the direct thing. But to me, it felt like that's not accurate, since they could still turn around and in a subsequent session, in the same session, just pass another bill or amend the bill.
To do what?
If it's being abused, couldn't they just write another law and pass that one?
Over the president's veto. So the issue is they have to go over the president's veto. It's a lot easier to do this.
Well, no, I mean, if they're saying without the legislative veto.
Yeah, they still need to get a majority in both houses, override the president's veto. So, for example, if both houses of Congress pass a bill saying deport Chadha, and President Reagan vetoed it, then we need 2/3 of both houses to override that. That's a lot of work.
Right? So then, did the Attorney General's ability to decide not to deport Chadha, was that effectively a veto by the president then?
Well,
that's what I'm saying.
Yes, in a way. I mean, this might be a nice introduction into the line on veto case, but this basically gave the president the power to veto a law with respect to a specific person. I want one point, Dave, and you're just will be easy. Read the last 3 words of Justice White's dissent, at the very bottom. The last 3 words.
Oh, I must dissent.
I must dissent. I must dissent. So it's tradition in the Supreme Court that when a justice writes a dissent, he says, I respectfully dissent. Any respect here? R-E-S-P-C-T. Right, none. This is the equivalent of dropping the mic on the Supreme Court, right? This happens maybe 2 or 3 times a year where a justice is so enraged by the decision that he or she simply says, I dissent, period. This is I must dissent, which is even worse. There are numbers on this. Justices Scalia and Ginsburg are top 2. I think Ginsburg has a slightly more because she's more often the minority of the dissent than Scalia is. But basically, the 2 of them lead the way with the I dissent. It's considered this stinging barb of like, ugh, this is crap. I can't even join this horrible opinion. So Justice White says, I must dissent. We already discussed Justice Rehnquist's dissent and the severability. He's right. The mere fact that a statute says we sever it doesn't mean you actually sever it. What actually matters is how the statute would function in the absence of the line item veto or the one-house veto. This statute would have never been enacted without the veto. And we'll actually come back to this when we discuss Obamacare in about a month or so of whether you can sever the individual mandate from the rest of the Affordable Care Act. So what happened afterwards? Chadha became a citizen. He eventually got it. He actually got married to an American citizen. They were married, and they had children here. And ultimately, he became a citizen. And I don't know what happened to him. But I'm sure he's around somewhere. Okay.
I just had a question.
Oh, hold on. Is that John?
Yeah.
John. Okay.
So from the college, this is a little bit much. But from the college, we have a necessary proper clause, and I'm trying to figure out how come you can interpret the Constitution thinking that sometimes it's if you think that necessary and proper is in terms of convenience, right? You understand that sort of question, then talking about Congress sort of putting out powers.
So John's question is a good one. He's asking, look, we saw you last week saying that Congress has this necessary and proper power, which means they can do whatever is convenient to what? Be specific.
Exercising their
enumerated powers, right?
So like, you want a horse for your bank or something like that. You can buy those things.
Okay. So they can do whatever is convenient to execute their enumerated powers, right? John, let me ask you this question. Is one of their enumerated powers giving the president authority?
No, but...
And I'll let you finish a second, but that's the answer, right?
Yeah.
The separation of powers, if they're violating the separation of powers, that is not something that's enumerated, and therefore the necessary and proper clause doesn't kick in.
Yeah. I was thinking that...
But you're right. The way Marshall read the Constitution in terms of getting flexibility is inconsistent with Chadha.
Yeah, that's okay.
I knew that's your point. Yeah.
I think that's
right. And Breyer in Clinton in New York and Justice White in Chadha, I think, articulate the Marshall perspective. Listen, let government do what it's got to do.
Yeah. So like generally, the way they saw the Constitution, like generally this is
the way who's they?
Or no, at least no from college the justice.
Marshall?
Yeah, sorry, Marshall.
Mm-hmm.
The way he sort of used it, understood it as being broader. Like that's what's in it. This is not just the bare bones of something, but if something's actually more useful in doing it this way,
right?
And that should win out.
So I mean,
using that as like a key theme, it seems like you can also.
So this is going to be a massive debate within constitutional law. I realize you're in class 4, yeah. But you're going to see this theme reemerge. I don't know how many times, where you have a formalistic way of reading, saying the separation of powers matter. That once these break down, it's problematic. And you have the Justice Breyer, the Justice White, Justice Jackson saying, listen, let's not be so formalistic. Let's let government operate. Yeah. And this is going to be an ongoing debate in class. Yeah, Tariq?
Yeah, just have a problem understanding this. So if the act goes unconstitutional.
Well, not the act, but the one-house veto, just one provision of the act.
So did he put Congress first and then Supreme Court look into it, or did he put Supreme Court first and Congress look into it?
Well, what's interesting is the one-house veto was enacted many years earlier, and the president signed into law. So what happened was the one-house veto was on the books for a long time. Then President Reagan's Attorney General said we want to deport Mr. Chadha. I'm sorry, we're not going to deport Mr. Chadha. And then the House of Representatives passed a veto over that. And then when they were about to deport Chadha, Chadha said, wait a minute, this one House veto is unconstitutional. And so that's why the case called INS v. Chadha. The INS was trying to deport Mr. or not deport Chadha. And he then challenged that in court. Understand?
So the Congress, one house said that we don't want it. We want it. We want
Yeah.
it.
Yeah.
Okay, and what was the
I'm sorry?
veto?
The president, the attorney general said we will not deport him. One house then vetoed that. And then there was an order of deportation. Chadha challenged it in court, and that's went to the Supreme Court. Understand? Any other questions on Chadha? This is Luis.
So if the president signed the bill into law, the president and Congress are
Yes.
in both. So that goes back to Jackson's idea.
I am so glad you said that, right? The president and Congress were both okay with this. Until President Reagan said, oh no, I don't like this anymore.
Yeah, and is that not like a joke for the previous president who signed it?
So we'll have cases this year where effectively we'll do a case called Zivotofsky in a couple weeks, right? Or maybe next, I can't remember what it is. The thrust of this bill was Congress said to the president, if a person, a U.S. citizen is born in Israel, in the city of Jerusalem, they're allowed to have their passport stamped that they were born in Israel. This was a case a year or two ago, right? President Bush, Bush 43, signed that into law. And then he claimed that that provision was unconstitutional and refused to comply with it. This happens a lot. By the way, Senators Clinton and Kerry both voted for that law and then refused to enforce as secretaries of state. So it goes all around. And Obama as well. He may not have been in the Senate at the time, but I think Clinton and Kerry definitely were. So basically, you have Congress enacts a law, the president signs it. Then the president says, no, this is unconstitutional, I want to enforce it. And then this went to the Supreme Court in the case we're about next week. But the mere fact the president signs a bill doesn't mean he necessarily agrees with it or will enforce it later. It's a tricky situation. Any other questions on Chadha? Yeah, Taylor?
Yeah, to be brief on it, because I know we kind of talked about it for a minute, but I started to wonder why the majority opinion was very formalistic in the way that decided that this legislative veto was unconstitutional. But since arguably the act itself allowing the Attorney General to make that decision, that judicial decision, like Powell said, why didn't they also say, well, that's unconstitutional too, so the whole thing is done? I mean,
So which is, yeah, I mean, so the question is, Taylor phrased the question well. They could have invalidated the one-house veto, or they could have invalidated giving the discretion to the AG, right? Right? They could have effectively said, no, you didn't comply with bicameralism presentment, or they could have said, non-delegation doctrine, the entire immigration system is like effed up, right? It's all messed up, right? Which would have been more dramatic?
Well, destroying the whole thing.
So they chose the path of least restriction, the path of least destruction. That's why Chief Justice Berger said we are not addressing the separation of powers question, right? He said that. We're going to rule on this fairly narrow point. Because had the court ruled that the delegation of authority to the AG was invalid, that would have invalidated basically the entire administrative state.
So it seems like then they were kind of finding a middle ground almost between what...
Yeah, it seems dramatic, but could have been much worse. Good question. Yeah. Anyone else on Chadha? Okay. Let's move on to the second case, Clinton v. New York. So this case has an interesting background. So the idea of a line item veto is something that many governors have. For example, in Texas, we have a line item veto where the governor is actually able to decide not to spend certain appropriations by the by the legislature in Austin. And the purpose of the line item veto is just that, right? We don't want a president to have to veto an entire law whenever he disagrees with one sentence. So using the Israeli passport example, right? This was a 1,000-page bill with everything you can imagine. Bush agreed with 99.9% of it. He did not agree with the Israeli passport deal, so he just vetoed that one provision. Wouldn't it be nice, convenient, for the president to be able to just strip out one line in a 1,000-page bill, right? Wouldn't it be awful if the president vetoed this 1,000-page bipartisan bill because he disagrees with one sentence? So the line item veto makes sense. Again, it's convenient, right? It makes government more efficient, allows bipartisan consensus. And if there's one sentence here he doesn't like, fine. If there's one sentence there he doesn't like, it makes sense for purposes of efficiency. So after the 1994 election, you may remember Newt Gingrich and the Republicans took the House of Representatives. That was the first time the Republicans controlled the House, I think, in 40 or 50 years. And Newt had something called the Contract with America that had various principles of fiscal conservatism that would rein in the size of the federal government. And one of these provisions was a line item veto. So now, Congress passes this bill, giving the president the power to veto a provision. So, Anna, what do you think President Clinton thought about this line item veto of Newt Gingrich and Republicans? What do you think he thought about it? Yeah, he loved it. Why do you think the President Clinton, Republican, Democrat, I don't care. Why do you think the president would want this power, Anna? Yeah. This is a president's best friend, right? No longer does he need to negotiate and fight over the details of funding bills. These appropriation bills are thousands of pages long. They fund everything. So now the president's like, yeah, you guys go pass whatever you want. I don't really care. And on the back end, I'll just strip out the stuff I don't like. So this was a bizarre enough effort of Congress giving up its own prerogative to the executive. Again, Congress was giving up its authority to repeal laws, or at least that's the majority characterizes it. We'll get to Scalia in a minute. But according to the majority, Congress was giving up its authority to repeal laws to the executive. So Delaney, what do we think again of the Congress giving up its own authority to the president? The president says that's fine with me, and Congress says, yeah, we're conservatives. We don't want all this money being spent. Go away. How do we make of this decision of the Congress to shift or delegate its power to the executive branch?
You were saying that once they give it, they can't come back and regulate it more.
Yeah. And I think this is what inspires majority opinion by Justice Stevens, right? Once Congress gives this sort of power up, gives this power away, it becomes very hard to return it to the Congress at a future point. It's possible. In this case, there's actually provisions to override it. So what happened here? First of all, John, can you please walk me through the process by which the line item veto works? How does President Clinton go about actually canceling, I'll use that word in scare quotes, canceling a funding provision? What actually happens?
I mean, so it's usually a spending bill.
Okay, so you start with the spending bill, Congress passes the budget. Okay, good.
Yeah, so it's used for a budget or spending bill.
Okay.
And, the executive can just go through the bill and cross out the things they doesn't want to allow, just like if they're, gangrene, what's gangrene, cut it off, and just let it go. But the rest is still good, and you can sign it. Okay, good. So there's a specific process that the president has to follow to cancel a bill. So first you have a funding bill. So long as it's, not, it's not an essential government function or it's not in the national interest, the president can decide to cancel it. After he decides to cancel that expenditure, he sends a message to Congress notifying it. Okay. After Congress receives a notification, Samuel, what happens after Congress has notified the cancellation? What can they do? Oh, you can take it. It's fine. No. Samuel, you want to take it? That's okay.
I remember exactly what it's called. They just send it back to them and say, no, we really do want that piece in.
It's called a disapproval bill.
Oh, that's right.
Both houses of Congress pass a disapproval bill. Okay? Both houses of Congress. I'm sorry? Yes. Well. I'm glad you said it that way. So what Congress does, they pass this disapproval bill. What happens to the disapproval bill, Samuel? Can the president veto that?
No.
Yes. The president can then veto the disapproval bill. And then what can Congress do to that?
And they
Override it. So let's walk through this process again, right? Both houses of Congress pass a spending bill. President signs into law. Okay, it's law. Then the president says, I'm going to cut out this funding for the city of New York. That's what the case is called, Clinton v. City of New York. Rudy Giuliani sued. I'm going to cut out this provision sending money to the city of New York. Okay? He sends a message to Congress. Congress then has the option of sending a disapproval bill. In other words, then both houses of Congress say, you know what? We do not agree with the president's cancellation. Put it back in. The president at that point has an option. He can either sign it or veto it. If the president vetoes the cancellation bill, it then requires 2/3 of the House and Senate to override it. Everyone get the process by which this works. Everyone understand the process. In this case, President Clinton followed the process meticulously, to use Justice Stevens' the majority is by Justice John Paul Stevens. Stevens was a Ford nominee, a moderate Republican who had gone to be the leader of the liberal wing of the court for almost 3 decades. He retired a few years ago. He was the 3rd longest serving justice. He was on the court forever, far too long, in my opinion. He was in the court for quite some time. And he had majority opinion in this case. And this is a case that's not really liberal or conservative. It's actually somewhat of a unique one. It's a case that I'm personally conflicted. Every time I read, I go back and forth. I mean, the majority opinion was by Justice Stevens. You had Breyer in dissent. You had Scalia in dissent. It was all over the place. So this is not your normal right versus left case. It's a very profound case, if I may. So here, Clinton followed this procedure. He canceled some funding for the city of New York. There was no return bill filed. And it was challenged in court. Okay. So first, Anthony, were the provisions of bicameralism and presentment, Chadha, followed here? Were the provisions of bicameralism and presentment strictly adhered to here?
Yeah.
Okay, explain why.
Because it went through, the president went through it and then decided, and then
Well, how does something become law? Walk me through the steps, please.
goes through the Congress,
Okay, it goes to the House, then,
the Senate,
then,
the president,
and then what happens?
signs it,
Okay, president signs it, then what happens?
it becomes law.
It's law. Okay. What happens here after President Clinton canceled the provision?
The Congress,
No. What happens after President Clinton immediately, once he canceled the provision? What happened to the statute? What happened to the law he had just signed? In part. It's as if he had taken, say it's a 100-page statute, he had just taken 1 page out of it. So instead of having a 100-page statute, now you have a 99-page statute. Was the law that he signed, Anthony, the same law after he canceled it? Okay. And this is the majority's holding. The president effectively made laws without bicameralism and presentment. The president made a new law, right? You had this 100-page bill, now you have this 99-page bill. They're not the same, right? If Congress passes a 100-page bill and the president only signs 99 of them, it's going to be a problem, right, for sure, but it's not law. So for the majority, by removing this one sentence, removing this 1 page from this massive bill, a different law is being executed. The court says if 1 paragraph was omitted, it would not be validly enacted. The court holds the line item veto gives the president the power to create a different law, one not voted on by Congress. The line item veto gives the president the power to make a different law. Because you had Law A with 100 pages, and you have Law B with 99 pages. They're not the same. That's what the majority says. I don't know if I agree with it, but that's what I'll get to with Scalia. But that's what the majority says. So even though, by all accounts, right, bicameralism presentment were complied with. House voted, Senate voted, President signed. House votes in the disapproval bill, Senate votes in the disapproval bill, President signs. The step of the president canceling it and taking a chunk out of the U.S. Code, taking a page out of the bill, That is what the majority says is unlawful. Any questions on the majority opinion? At least as far as they went. It was fairly short. It wasn't very long, the majority opinion. Most of this stuff was in the dissent. Is that Paul? Yep. Did Justice Stevens address whether this disrupts the balance of powers? Whether it disrupts the separation of powers? He said what he did or didn't do. Paul, let me ask you a different way. Did Justice Stevens address whether Congress giving this power over a veto to the president violates separation of powers? They addressed that issue. You got it? Is that Zach? Oh, this again. No, I go this way, so just so you know for the future, okay? I go like this. Okay, this way back to Zach. Right from David, yeah. So,
He does address that issue.
does he?
Well, not directly, but he does talk about how it gives the president too much power.
Okay, but does he actually invalidate it because it violates separation of powers?
No, but
No, that's right. It's not right. Right, okay. You're good. You're good. Don't wander away from the right answer. So, Justice Stevens says we will not consider, quote, if it disrupts the balance of powers between the three branches. Okay, so I'll come back to you, Paul. Why do you think Justice Stevens does not want to address whether this violates separation of powers, giving this veto power, this legislative power to the Congress is unlawful? Why do you think he doesn't want to go there?
Maybe he was afraid of how far it extended to other things.
Yeah. The court generally tries to rule as narrowly as possible. Had they ruled in this case that there's a violation of the non-delegation doctrine, it would validate a lot of other stuff. So they rule narrowly. So this is just like Chadha, right? This is just like Chadha in a sense. They ruled on very narrow Article 1, Section 7 grounds. Both these cases said no bicameralism presentment. And they're basically actually mirror images of each other if you think about it, right? They're mirror images. Chadha said Congress does not have the power to veto laws. And Clinton said the president doesn't have the power to make laws. Chadha, Congress tried to assume an executive power. And in Clinton, the president tried to assume a legislative power. They're mirror images of each other. They're actually inverted. And both of them were very formalistic applications of bicameralism presentment, saying the only way to make laws is one house, two house, signature, or veto. That's it. There's no other method by which laws can be enacted. There's no other method by which laws can be changed. Okay. Any questions on the majority opinion in New York? Yeah.
So the line of veto is unconstitutional. It doesn't matter if it's for the bill we pass or not.
I don't understand what you're saying.
So let's say that the bill becomes law already.
The president signed it.
The president signed it.
Okay.
And then he's saying, oh, I don't like this item. Does that matter? Is it different? Then he doesn't sign it. It's not.
Well, if the president doesn't sign it, it's not law.
But it becomes a law.
Once it becomes a law, according to the majority, it can't be altered.
But did he do that before he signed it or after?
In this case, he signed it, then he canceled the provisions.
Is that why it's?
Well, that was how the bill worked. If the president vetoes it, saying, I don't like this provision, I'm going to veto it, that's fine. But the president here was he signed the entire thing, then vetoed specific provisions. The question in the majority opinion. We'll get to the dissents in a minute. Let's do Justice Breyer first. We'll come back to Kennedy in a few minutes. Okay, you're up. Is that Zulma?
Yes.
Zulma, what was Justice Breyer? By the way, Justice Stephen Breyer, he was a Clinton appointee, considered very pragmatic and moderate. He also has this horrible habit of speaking uninterrupted. So the Supreme Court transcripts, they print out the questions being asked. And Justice Breyer has this horrible habit of speaking by himself for 2 minutes at a time. He has these 2-minute-long questions that go nowhere. If you actually look in the transcript, the entire page is just him. So I call these Breyer pages. And I actually counted, I keep track of these. He actually once spoke for almost 2.5 minutes by himself without even asking a question. And then there was no question. He's like, how would you react to that at the end? Or what do you think? You know, so he's interesting. He's an interesting dude. He's a very interesting guy. He's also fluent in French. So Zolma, what does Justice Breyer say about the considerations? How does he approach this case?
When he first did this, I thought unconstitutional. So it is constitutional because supposedly it's already giving him the president power that he has, right? It's not creating new power.
Good, but let's look more generally. Zolma, let me ask you this question. Justice Breyer, right? Is he closer to the Justice Black or to the Justice Jackson school of thought in Youngstown? Is he closer to Justice Berger in Chadha or Justice White in dissent? Where does Justice Breyer fit in? And by the way, these are the questions you're going to need to know for the exam, so make sure you pay very close attention to these sorts of questions. Transitioning doctrines across generations, right? How would you fit him in, Zolma? Breyer. I can throw you in the Breyer patch if you don't know. It's okay.
I think he's more formal.
Formal? Why would you say that?
He's not talking about, okay, like let him do what needs to be done so it's more convenient. Well, if you say which part is not unconstitutional, so like let's rule because through the Constitution, let's look at it.
That's one answer. Okay. Is that Mirza? Mirza, sorry. Mirza, how would you compare Justice Breyer to the opinions we've done before? Where does he fall?
Like, speaks more on the functionality.
Yeah,
Like
functionality. Is he more Jackson or is he more Black?
I have to read those opinions again. But,
No, you don't. No, you need to remember them.
Well, okay, then I have to read them.
How about the opinion we did 20 minutes ago, Chadha? Is he more like Berger or is he more like White?
Probably more like Berger.
You're,
Doesn't make it. Wait, aren't there four separate? There's
No.
like 3 separation of power issues, and he's like, the answer is no to all of them.
Does he look at the text of the Constitution? Does he? You're shaking your head, Heidi. Does Breyer even look at the text of the Constitution? No, it doesn't matter. He does not keep a Constitution in his heart. I'm almost positive. Heidi, does Breyer look at the text of the Constitution? Does he look? Is he like Black or like Berger? A very formalistic approach. Who is he like here? Why is he like Jackson?
Because he looks at more what makes sense.
What makes sense? He wrote a book. What's it called? Making Democracy Work or Making Government? What the heck is it called? I think it's Making Democracy Work. I think that's the name. Is he Making Democracy Work? That's it. Yeah. Making our democracy work. Right. Breyer's entire mode is it. Breyer's entire mode of thinking is how to make democracy work. And in an interview he gave about this book, someone asked him, like, what's the most important word? Like, he said the most important aspect of our Constitution is democracy. What's the problem with Justice Breyer's conclusion that the most important aspect of our Constitution is democracy? You want to take a guess? The word appears nowhere in the Constitution. That's what I'm saying. He doesn't care about the text of the Constitution. He is motivated by pragmatic concerns. This is not to say he's bad. In fact, I think he makes a lot of strong points, right? He makes a lot of strong points I think require refutation, right? But there is no democracy clause in our Constitution, which is why the text is irrelevant. He is a pragmatist. He is not formalist. He is a pragmatist. He's not interested in what James Madison said about bicameralism presentment. He's not interested in Article 1, Section 7 and votes and disapprovals. He's interested in what works best, right? What works best. Lexis, why does Breyer think that this sort of discretion is an effective way to make our democracy work? Not to be confused with Make America Great Again, right? Why does he, Alexis, why does he think that this is a good way of making our democracy work?
Well, he talks about how the president is not actually changing anything, and that it's specific to the budget.
No, but practically speaking, why is this provision something that makes America more efficient than makes America? That makes government more efficient, makes it more democratic, makes it more representative. What about this line of veto? So Ryan?
They actually mentioned that they have to pass appropriations bills and that it's more efficient instead of just sending hundreds or thousands of different ones.
Yeah. Here's the rub, right? Breyer says, and again, I beat up on Breyer, but I think he makes good points. Breyer says, in the time of George Washington, in the first presidency, the entire appropriation bill was a page long, right? The entire budget for the U.S. government was a page long. And if George Washington didn't like one sentence on that page, he could have vetoed it. And in 5 minutes, Congress would have passed a revised, budget that would have had it. Today, Breyer says, we have these appropriation bills that are thousands of pages long. No one even reads them, right? No one reads these bills. It's impossible. They're released so quickly before the vote, you can't read quickly enough to the entire thing, right? You can't read these bills. So Breyer says, listen, in our day and age, it's not practical for the president to veto a bill because he dislikes one sentence. This line item veto bill makes things efficient, right? It doesn't frustrate bipartisan compromise to allow the president to later axe one provision. And even if the president destroys one provision, Congress can then override him, right? Congress can always override him. So there's still the backup of the separation of powers.
Well, I feel like he also contradicts himself a little bit because throughout the opinion, he talks almost at length about efficiency and how the one-line veto is really not such a bad deal and how the president didn't exactly amend the law. But then he sort of contradicts himself and he says, well, we can leave this all in place, and in order to safeguard that, we'll just introduce in every line item of every following bill a clause that says it'll be subject to the one-line veto or not.
Right. So what Breyer also says is, I'll get to you in a second. What Breyer also says is that Congress could accomplish these exact same things by different means. And Scalia makes this point, I think, more forcefully, right? If Congress had simply said, to answer Dan's question, where was I up to? Up front. Is that Monica? So Monica, what happens if Congress had passed a bill saying, Mr. President, you can spend as much as $1 million on New York City. You can spend less, but you can spend as much as $1 million in New York City. And say President Clinton said, okay, I'll only spend 100,000. Would there be any constitutional problem with that?
It's an executive function.
Okay. But here's the risk, right? How would the members of Congress from New York feel about a bill giving them that sort of discretion?
They were being singled out and the executive branch wasn't fulfilling its duty to enact.
They were not bringing the bacon home.
Right. Yes.
So had Congress actually done what Dan just said, they passed a bill saying, okay, this money for New York, you can only spend 100 million. You can spend as much as $1 million, but you can spend less. The people from New York, would they have ever voted for that bill? Would the New York senators ever vote for a bill like that? Of course not. So this is what it does. It shifts responsibility, right? When Congress tells the president you can spend as much as this or you can spend less, the members of that district know that it's their representative who did it. But here, Congress is shifting the blame to the president. So now don't blame the representatives from New York. Blame the president for doing it. Oh, and we couldn't override the veto. Too complicated, right? So what this bill does, and Breyer doesn't mention this point explicitly, but it's the consequence, is it shifts the power. It shifts the accountability for laws from the Congress to the president.
So why couldn't Congress interpret it as when they're giving up the alignment veto, what they're doing is that they're implicitly consenting to whatever the law that the president is already negotiating with already. So
Right.
like before in Congress would say, well, you would negotiate in your committees. You're like, well, the president may want something like this, like this. But when it's on the desk, what the line item veto is really doing, it's not some executive power. It's literally just an extension of this negotiating power that happened.
But after the fact.
Yeah, but if but Congress is consented to that.
And the question in this case
they
was
have the last word to that contract.
And the question in this case was twofold, right? So the narrow issue was whether this complies with bicameralism presentment. It was on those grounds the court ruled against it. But the bigger question is, can they do that? Do the separation of powers allow this negotiation after the fact? Well, it's not, don't say after the fact, that's not the issue, right? Can the Congress give the president the power to do this negotiation after the fact? And again, the court ruled narrowly on bicameralism grounds, but the bigger separation of powers issue was lurking, and all the justices avoided that. So raise your hand up. No. All right, any other questions on the Justice Breyer dissent? Breyer, he always has principles. He loves counting lists of principles, which don't get you anywhere, right? But basically he says, and I think someone made this point before, maybe it was Luis, the president and Congress agree here, right? Brody, Clinton and Newt Gingrich agree on how to share powers. Breyer says, why are the courts telling them no? Why? What happens when the parties of Congress agree on how to share their powers? Should that influence how the judges decide?
Well, with you've got Congress and the president agreeing,
Yeah.
That means that the court needs to be alone.
What did Jackson say? But what happens when the president and Congress are in agreement? What did Jackson say?
That the court needs to
Defer. So here we have the situation where the president agrees with it, the Republican Congress. I mean, look, Newt Gingrich and Bill Clinton, they didn't agree on much, right? But they agreed on this. So under Jackson, how come the court's being so skeptical? Young staff, you notice, wasn't cited in this case by the majority, but effectively it's a formalism of black. It's saying, look, we have this strict procedure in Article 1, Section 7. We're going to follow it. We're going to follow it. We're not interested in this. Breyer writes that, this is basically something Congress can do. Maybe it skirts a constitutional edge, but we should defer to Congress. We should defer to the democratic process. Okay. Any questions on Breyer? All right, move on to Kennedy. Justice Kennedy is our overlord. He's effectively decided virtually every major issue of constitutional law in the last 25 years. His power is without bounds. In this case, though, he's very resentful of Justice Breyer's dissent. So here we are to Byron. What does Justice Kennedy said about this issue?
He was very skeptical of it because saying that liberty is always at stake. Liberty is at stake when you kind of start to have this kind of transgression.
What does it mean, Byron, that liberty is at stake when the separation of powers are violated? What does Breyer mean here?
It means the branches aren't functioning as they're intended to.
You didn't answer my question, but I'm glad you. What does that mean for the citizens of the individual liberty?
Your despotism comes around.
Okay. So Breyer has this lengthy philosophical history which pervades much of his writing. Just as Breyer sees that federalism and the separation of powers are the safeguards of our freedom. I think I mentioned this in the last class, but more or less from Kennedy. When the Constitution was first ratified in 1789, there was no Bill of Rights. It was the structure of the Constitution that was viewed as the means by which individual liberty can be preserved. By checking the power at each stage, it prevented one branch from becoming too powerful. Breyer feared that even if Congress agrees to shift power to the president, it's giving the president power that will not be relinquished back. And that when one branch becomes too dangerous, too powerful, it's our freedom that are at risk. He writes, quote, "Liberty is always at stake when one or more branches seek to transgress the separation of powers." One or more branches. So contra Jackson, even if both branches agree to shift their power, Kennedy says, no go. Kennedy writes, the separation of powers was designed to implement a fundamental insight. The concentration of powers in the hands of a single branch is a threat to liberty. Right? If you recall the Federalist, the accumulation of all powers, legislative, executive, and judiciary in the same hands is the very definition of tyranny. Okay? And Kennedy notes, in recent years, we often think of freedom in terms of the Bill of Rights, the First Amendment, the Fourth Amendment. No, 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 no. It was a separation of powers and federalism that secured the liberties in this political sense. Okay. Kennedy writes, it does not matter that Congress relinquished this power. Very often, governments relinquish their own powers. They're very willing to give up power because they don't like accountability. That's less the administrative state. They can't manage this regulatory behemoth, so let the president do whatever he wants, give the Attorney General this authority. Not for us to decide. Kennedy writes that the abdication of responsibility, that Congress giving up its responsibility, is not part of the constitutional design, that this threatens the very liberties of the citizens. We'll come back to Kennedy's discussion of this in a case called Noel Canning, which we'll do, I think, next week. It's a recent appointment case. I want you to think very carefully about Kennedy's opinion here when we do Noel Canning next week. Okay? All right. Any questions on Kennedy? Or Kennedy's opinion? I can't answer questions on him. None of us know. We'll come back to Kennedy a lot this year. Okay. The final decision is by Justice Antonin Scalia. Justice Scalia was a Reagan nominee. He's considered the founder, or at least the patron saint, if you will, of modern-day originalism. This is the vision that, you know, the Constitution should be understood how it was originally understood at the time of its enactment. So at first blush, you know, you would think, how is Scalia going to vote here? He's a textualist, right? Of course Scalia is going to vote, say that the Article 1, Section 7 was complied with. He is the most formal justice in the court, right? Scalia's vote. Thank you. Scotty, what's Scalia's argument here? Why is Scalia in dissent? Why is he not saying, yes, Article 1, Section 7, go for it, good?
He goes, it is constitutional on the face of it.
Why?
Basically, because it's not the president until he can like this.
I'm sorry, say that again?
They aren't told no.
I know what you're saying. Sky, let me ask you this question, right? I mentioned this before. What happens if Congress passed a statute telling the president, you can spend as much as $1 million in New York? You can spend less, but you can spend as much as $1 million in New York. Would there be any constitutional problem there? Any problem whatsoever? How is this any different? Scalia asks, how is this any different? He says it's not. This is one of my favorite lines in Supreme Court history. It's in the very last paragraph of his dissent. You know what the line I'm thinking of? You know, is this Robin? The very last paragraph of his opinions, all the way at the end. My favorite Scalia lines ever. You know what the line I'm thinking of? What does he say about the title of the bill? The very end of his opinion. Anyone have it? I'll come back to you. Yeah.
Faked out the Supreme Court.
He faked out the Supreme Court. Rob, I'll come back in a second, right? Scalia says the title of the bill succeeded in faking out the Supreme Court. Robin, what does Scalia mean by that?
Basically, the president having the power to.
Robin, let me ask you this question. Did the line item veto bill actually give the president the power to veto laws? According to Scalia. No. What does it simply do? No. Katie, what does the bill actually do? It gave him discretionary authority. Scalia says, you guys got faked out, right? Psych, right? This is not what the bill does. All it does is say, going forward, any appropriation for $1 million says you can spend as much as that. It's as if Congress had asserted in every single appropriation bill a single sentence that said the president can spend as much as X. He can spend less, but he can spend as much as X. But it's like, what the heck are we doing here, right? The effort to sell this to the public, to call it a line item veto, was misleading. It doesn't actually veto any laws. It gives the president discretion he's had since the time of George Washington and Thomas Jefferson. All right? Everyone see that? Scalia, this is why I go back and forth in this case. I think I usually go with Scalia, but sometimes I go with Stevens. I go back and forth on who's right. It really depends how you characterize the bill. I think Kennedy makes good points as well. Breyer is Breyer. So Scalia says you guys got faked out. Scalia also talked about the non-delegation doctrine, which is why I mentioned it front, because you won't get to the very end of your reading for the class. Scalia says, well, you know, this is not much worse than rulemaking, right? This is not much worse than making these than letting these administrative agencies make law. Scalia has also come to terms with the New Deal. He said, you know what, New Deal, administrative state, whatever, I'm not going to challenge it. So as long as we're letting these administrative agencies basically make law, what's the big deal with letting the president do this? But that's not going to be the issue here. The court's not going to question whether Congress can give the president the power to veto, because Scalia said there's no actual veto. It's all just a prank, right? You know, it's Ashton Kutcher. You know, it's a joke. There's no actual veto here. There's no difference than simply not spending funds that were appropriated. All right, questions on Clinton v. New York, Scalia's dissent. Taylor.
Yeah, because the majority basically hinged their decision on the president unilaterally amending the law, basically.
Yes, according to the majority, the president was actually modifying the law. Exactly right.
Scalia is taking the opposite view and saying, well, he's not changing anything. All he's doing is effectively saying, well, they gave me the ability to spend $1 million. I'm just going to choose to spend zero.
Exactly.
So my issue when we were talking about this before class was that I felt like what this was doing was that the next president, when he comes in, wouldn't have the option, or later in the same budget period, wouldn't have the option to change that because they've effectively taken away a part of the.
Well, appropriations last only 2 years.
Right, but I'm saying, so even the same president, right? So if they come in, okay, let me back up. So basically, does the line item veto act, did it actually give the president the ability to take a line of text and take it out?
No, the line was not removed from the U.S. Code.
Right. So then what the majority, that's exactly what they hinged their on. So why?
They say it's as if he had ripped a chunk of the U.S. Code. The U.S. Code stays the same. It's not modified. But simply the president says, I am not going to spend that one part. Right? The president does not amend the U.S. Code through the line item veto act. Right? The statute book doesn't have any record that the president changed the law. What the majority says is, here we have the statute book, right? But the president's doing something different. Therefore, it's not complying with the law. Again, I go back and forth. I think the majority has strong points. I think the dissent has strong points. It's probably the tougher case we'll have all year. I go back and forth. Scotty?
I have a question about how our final amendment, and how our, do you want us to like the jurisprudence of, Judge A's a pragmatist, Judge B's formalistic, etc.
Yeah.
There are scores and scores of justices. Do you want to know which ones to focus on?
The ones we cover in class.
Oh, that's it?
Yeah. Yeah, the ones we cover in class. Okay. Any other questions on Clinton? It's a tough case. It's a really tough case. Let's talk briefly about the other provisions of Article 1, Section Article 1. I assigned these here because they don't fit anywhere else. But I want you at least to know about them. So we already discussed the Bill of Attainder provision. The Bill of Attainder is in Article 1, Section 10. And it basically says you can't have a legislative act targeted at an individual. Arguably, in Chadha, the one-house veto for Chadha named him. I think Justice Powell is probably right. That was probably that was probably a Bill of Attainder. Although the court has, in a case called Nixon versus GSA, Nixon versus General Service Administration, which involved Richard Nixon kept a presidential a secret recording device in the Oval Office. So whenever anyone would start talking, he would record them. And as you know, President Nixon engaged in significant illegal activities during his administration. He was later pardoned by President Ford. You'll be hearing a lot about the presidential pardon of Ford in the next year. Stay tuned. So the question was, Nixon said, I don't want to turn these tapes over. They're my property. And Congress passed a bill saying, President Nixon must turn over the tapes. Okay. That seems like a very clear Bill of Attainder. But in a decision by Justice William Brennan, Justice Brennan, who we'll talk a lot about, was a, I don't know what to call him, speaking of the dead, he did what he wanted to. He did whatever he could get 5 votes to do. And he didn't want to rule against the government here. So he basically wrote this opinion which said, well, you know, this is not really a Bill of Attainder. Even though Nixon was mentioned by name. There's no law here. Brennan made it up. Don't try and explain it. But the consequence of this is that the Bill of Attainder clause is basically worthless after the Nixon case. Yeah.
With regard to the Nixon here,
Yeah.
and you expressed that you believe it was a Bill of Attainder as well.
Yeah, it was.
According to the definition here, a Bill of Attainder is a legislative act targeted at only one or few individuals that declares them to be guilty of a crime and specifies the punishment they must suffer. It seems to me like the deal against Nixon was something more that had to do with property.
So the definition you read is accurate, but it wasn't just crime. It also referred to certain civil judgments. So they couldn't target a person for a civil judgment as well. In other words, Nixon was penalized. They said, we're going to pass a law targeting you and only you. That is something which a court can do as adjudicative. It can't be done through Congress. This came up a lot during the 1950s. There was a case I didn't ask you called United States versus Brown, where Congress basically said, if you've ever been a member of the Communist Party, you lose your citizenship, right? That's not a criminal matter. That's actually a civil proceeding. And the court held that that was a Bill of Attainder. This was far more strict than what happened in the Brown case. The case, and if you want to read it, I didn't assign it. Okay. All right, any other questions on Bill of Attainder? So let's move on to the next clause, ex post facto, which I think someone mentioned earlier. So both the states and the federal governments are prohibited from passing ex post facto laws. These are basically laws that punish activity retroactively. It'd be like this. I drive on the highway today 70 miles an hour, and the speed limit's 75. Tomorrow, the legislature says, no, the speed limit was actually 60 yesterday. And they write me a ticket. No go. You can't retroactively punish someone for a law change after the fact. This came up in a case involving sex offender registries, which people know shockingly little about. But under these laws, even if you had convicted a certain sex crime decades earlier, and you've already served your time and you got out, these laws require that you register as a sex offender, which it requires you to tell the government where you live. You can't live in certain places with your children. By the way, you can go to places with children, you just can't live there, which makes these laws idiotic. The idea that you can't live somewhere but you can go to a park and visit is silly. The court upheld this provision, saying that it was not punitive, it was not criminal, it was a civil registration. And this was the Smith v. Doe case. Okay, any questions on ex post facto? It's a small part because it almost never comes up. It's a very rare provision, but at least you should be aware of it. Yes, sir?
You said that it was the end of it, public?
Civil. Yeah, the court held that the registration as a sex offender was a civil punishment, not a criminal punishment. Therefore, ex post facto didn't apply. Yeah.
As to what Bill of Attainder have they drawn lines for what small groups of individuals mean?
After the Nixon case, it doesn't matter anymore. I mean, the Nixon case basically read the Bill of Attainder clause out of the Constitution, another chunk they cut off. That was a decision that can only be explained as a product of its times. There's no good law there, I'm sorry. I've tried it. There's nothing to teach. I say that rarely, maybe once or twice a semester. There's no law there. They gave it to Brennan because that's what Brennan does best. So, the final provision is one also that doesn't come up much anymore, is the contracts clause. Article 1, Section 10 says states cannot impair the obligations of contracts. Believe it or not, in the first, 50 years of the Republic, this was like the most important clause of the Constitution, right? Why? Because the Constitution put almost no limitations on the states. Recall the Bill of Rights only applied to the federal government. The Bill of Rights did not apply to the states. So basically, the only things that states couldn't do were Bill of Attainder, ex post facto, or contract violations. So smart lawyers did everything in their power to squeeze everything they could think of into a contracts clause violation. And it basically says Congress can't impair the obligation of contracts. And over the years, the court has read this out of the Constitution also. They basically said it doesn't apply to new contracts, And then in the 1930s, they basically said it doesn't mean anything. The case was called Home Building and Loan Association versus Blaisdell. During the Great Depression, Minnesota enacted a law prohibiting foreclosures of homes. And that may sound like a great idea. Why should we foreclose homes, right? But prohibiting foreclosure violates a contract. You have a mortgage, you don't pay your mortgage, they foreclose. So basically, the state of Minnesota violated, thousands of mortgages. The Supreme Court said, yeah, it's probably a violation of the Constitution, but we have economic crisis, so we'll just ignore that for now. And the court read that out of the Constitution as well. So these three provisions, had a lot of teeth, have all been disregarded, and don't really have much weight anymore. You see the idea of cutting chunks out of the Constitution happens quite frequently. Okay. Any questions on Bill of Attainder, ex post facto, or what's the other one? Or contract clause? Questions? All right, no class on Thursday. I'll see you on Tuesday. Thank you very much.